All right, so it appears that Florida, their state law that allowed Twitter users, social media users, except for Walt Disney because they're in Florida, they made them exempt. You can actually sue those platforms, I believe, in Florida state court for being censored or any kind of being treated unfairly. Now, this is a huge, huge constitutional issue because what the courts basically are going to say is those free speech platforms are private organizations, they're private beings, which is kind of funny. Again, is you have like I guess the corporate personhood might be coming back like to haunt Republicans, but they're saying that they basically have the freedom of speech to be able to curate content and all of that kind of stuff. So it says an appeals court finds Florida's social media law unconstitutional. Florida law intended to punish social media platforms such as Facebook and Twitter is an unconstitutional violation of the First Amendment. A federal appeals court ruled Monday, dealing a major victory to companies who had been accused by GOP Governor Ron DeSantis of discriminating against conservative thought. Three-judge panel of the Atlanta-based 11th U.S. Circuit Court of Appeals unanimously concluded that it was overreach for DeSantis and the Republican-led Florida legislature to tell the social media companies how to conduct their work under the Constitution's free speech guarantee. Put simply, with minor exceptions, the government can't tell a private person or entity what to say or how to say it, said Circuit Judge Kevin Newsom, an appointee of former President Donald Trump, in the opinion. We hold that it is substantially likely that social media companies, even the biggest ones, are private actors whose rights the First Amendment protects. The ruling upholds a similar decision by a Florida federal district judge on the law. That's not a Florida state judge. That's a federal district judge located in Florida. It's an important distinction, which was signed by DeSantis in 2021. It's part of an overall conservative effort to portray social media companies as generally liberal in outlook and hostile to ideas outside of that viewpoint, especially from the political right. Some of these massive, massive companies in Silicon Valley are exerting a power over our population that really has no precedent in American history, DeSantis said during a May 2021 bill signing ceremony. One of their major missions seems to be suppressing ideas. So again, this is interesting. There's Republicans saying that they want the federal government, or the government, I guess in this case. I don't know if he would support like a federal government law or not. This is a state level law, but I'm sure he would also support a federal government level law. The government to come in and regulate private business. So that's pretty interesting to see, right? The panel found that content moderation and curation is constitutionally protected. However, the appeals panel ruled that the tech companies' actions were protected, with Judge Newsom writing that Facebook, Twitter, TikTok, and others are engaged in constitutionally protected expressive activity when they moderate and curate the content that they disseminate on their platforms. So essentially what the court is saying is, as private actors, they have the right to free speech, and them curating the shit on their platform itself is literally free speech. So that's what they're saying. They're saying, no, your right to this platform isn't free speech. What's actually free speech is them making the decisions on how to disseminate their content. And so based on that, they are deeming this Florida state law to be unconstitutional. I do wonder, I am curious because this is a constitutional question. I'm really curious what the level of scrutiny was applied. I wonder if they applied a strict scrutiny test to this ruling or not. If you guys don't know, the three main scrutinies, you have a rational basis test that's brought up. With the rational basis test, it's these are what happens when you're trying to challenge the constitutionality of a law. Rational basis test is the weakest test. It puts the onus on the challenger of the government who passed the law. So like if you wanted to challenge some kind of law saying this is unconstitutional, a rational basis test would put the onus on you, would put the burden of proof on you to prove that there's no rational basis for the government doing this whatsoever. Almost always with those tests, laws are deemed constitutional. With the intermediate scrutiny test, it's like somewhere in the middle. But the onus is on the government in that situation. The burden of proof is on the government, but it's a higher standard to prove, though. It's like I don't remember the exact verbiage of the standard, but there's a specific standard where you have to do it in a way where it's it's doing the least damage, and it serves I don't know if is it serve a government interest, or I don't know if that's strict scrutiny, but then strict scrutiny is the strongest one. The onus is on the government to prove that there is some kind of super important government interest, public safety, public health, that threat from invasion, those kinds of things. So for example, like if a law, we have court precedent on forced quarantines at the border, right? The federal government has the power to quarantine people entering their borders, mandatory, right? But that's a liberty violation of the Fifth Amendment, right? Their right to life, liberty, and property. So without due process. So, what you'll apply is, you can apply a strict scrutiny test, and that puts the burden of proof on the government to say, okay, you have to prove that this is, very razor thin in its goals, and it's also making sure that there's some kind of like supreme government interest at heart here, because there's a fundamental liberty that is being challenged here. And so that's when a strict scrutiny test is applied. I do wonder which one it would be. I would imagine it would have to be a strict scrutiny test, but, I think this would have to be a strict scrutiny test. And I think because the strict scrutiny test is the one where I don't know if most strict scrutiny cases with strict scrutiny applied end up being deemed unconstitutional. But since this is a First Amendment right, I would assume it would have to be a strict scrutiny test that's applied, because that's literally the most fundamental liberty that we have. So I would imagine it would have to be, but would love to know that if anybody knows that here. There was no immediate response to emails Monday afternoon from DeSantis' press secretary, communications director on the ruling. DeSantis running for re-election this year and eyeing a potential run for the 2024 GOP presidential nomination. He was the first governor to sign a bill like this into law, although similar ones have been proposed in other states. One of those in Texas was allowed to go in effect by the 5th U.S. Circuit Court of Appeals. The tech companies involved there are asking for emergency U.S. Supreme Court review on whether to block it. No decision on that was immediately released. So anyways, basically, that's what's going on, and it's going to be interesting because I imagine this will probably go to the Supreme Court. Considering how right-wing the Supreme Court is right now, though, I genuinely believe they'll probably overturn this. I genuinely think there's a really strong chance they're going to overturn this, especially if they're overturning cases like Roe v. Wade already. This is something where, because they are right-wing, and someone like Clarence Thomas is a complete lunatic. Not only is he a complete lunatic, but he's being influenced by his wife Ginny Thomas, who's like a straight-up QAnoner, like complete off the grid, like Kanye off the grid, you know what I'm saying? Like crazy person. And she's, behind the scenes pulling a bunch of strings, like messaging other Republicans and stuff. So she clearly has a lot of pull and influence too. So this is a situation where, unfortunately, I'm very fearful that, there is going to be an overturning here. But there's always a question, whether fearful is the question or not, because you have to decide really whether or not you support these kinds of private platforms having their right to curate content and that kind of thing. And so there's still that debate going on, and I'm actually not decided on whether or not these social media platforms should be looked at private actors or not, because honestly I find my position on these kinds of like free speech situations of social media platforms, like when you can take someone off, to be kind of nuanced and a bit detailed. So I'm not actually sure. Basically people want to make these platforms, like public utilities, because it's where the square of speech is, where people speak and converse. But because they're private platforms, they have their right to free speech, which includes curating content that they want to curate. So I'm actually not sure where I fall on this. So I guess I don't really have a fear of the Supreme Court overturning this case, because I'm not 100% sure where I fall on this situation. But definitely an interesting situation to keep an eye on.